The biggest mistake that I see all the time, which messes up the doctors, is they don't, in their report, provide a detailed explanation of how the rating was performed. Okay? So this is the way it usually goes. I performed an impairment rating of the 6th edition. Based upon my examination and my impairment rating, the person has a 6% permanent impairment rating. Okay? How did you get to the 6%? When you ask the doctor at deposition, then they fumble and bumble. Well, based on my education and experience, it's 6%. How did you get the 6%? Well, you know, if I had the book here, I could tell you, well, here's the book, doctor. Fortunately, I brought it along. Show me how you did your impairment rating. Well, it's a very complex situation. Yep, that's why you're getting paid the big bucks. Show me how you did it, doctor. And they can't show you. Okay, I don't know who did it or how they did it. Nobody knows. And that's never going to fly. So the doctors that are adept at this put the rating in the report. They say, this is how I did it. I think there's an example here. Okay? This is how I arrived at the impairment rating. Some of them are pretty complex. But if you have that in your report, when they take your deposition or trial testimony and they ask you how you arrived, they say, I'm going to refer to my report, counsel. And then you refer to your report and tell them chapter and verse how you did it. How I did it is like on page 23 of my report. I did this, did that, use that chart, use this chart, use this table, use this page, whatever. I combined it, I added it, and so on and so forth, and 6%. Okay? So that makes it a hell of a lot easier than just saying 6% and then not being able to defend it. Okay? Because your report and your testimony is of no value if you can't explain it and defend it, just like the judge was saying. How? How did you get there? Why did you do it that way? So this is an important point. And by the way, if you don't know how to do impairment ratings, just tell the client, I don't do impairment ratings. Don't just make something up, because that's not going to fly. You just can't turn to page 23, look up the shoulders and say shoulders 6%, because there's 6 other chapters that relate to that. Okay? It's all interrelated. So my suggestion is get some training if you're going to do impairment ratings. Questions about that? Judge, while we get this, I assume that you see impairment ratings like this kind of thing? Like
I do, yep.
What kind of things do you see there?
This sounds really simple and almost silly, but I find sometimes that practitioners don't actually read the rule. So in the jurisdiction I am on the bench in, we have, for instance, it'll say for neck or back conditions, there needs to be objective findings on a CT or MRI. Okay, that's pretty basic. But then also ongoing substantiated objective findings like reduced range of motion, muscle spasm, etc. And so I get the rating where it says, well, 3.5% under whatever the rule is, but no explanation. And then I'm looking at the medical records that I have, and I'm not really seeing reduced range of motion, or I'm not seeing persistent muscle spasms. So if the rule requires whatever the 3 prongs are, make sure that, one, you know what those 3 prongs are, the threshold is, and that, from my perspective, I appreciate somebody saying, look, it's, you know, you'll see it from Dr. So-and-so's records on examination. There's persistent reduced range of motion, or you will see on examination there's persistent muscle spasm, because I need all those parts to actually assess or award the rating. So that's, I guess, the biggest thing, that I see that there are parts missing that don't substantiate the rating that's actually given.
Right, and the other thing is, which we're going to get to in a minute, I think, is tell us which edition of the guide you used. Very often the doctors don't say which edition they use, which becomes extremely important, especially if you want to get it right. Are you using the right edition? If not, there's a big problem right there. And again, as we talked about this all day long, you're in a medical legal environment now. Okay? Half of it's medicine, half of it's the law. So you're applying the medicine to the law. So if you don't know the law and how it's to be applied, your opinions are, problematic, because you're not applying it to the law. So if the law says you need 3 things, then you need to tell us if you have the 3 things or not. If you don't say that, then we don't know that. and then you're going to get questioned about it. And again, as I said before, the better your report, the easier it is for you to testify because it's all in the report, okay? You don't want to have to, on the fly, try to testify about how you did an impairment rating that's not written down, because that could be very, very difficult. And most doctors can't do it.